Welcome to Topics and Decisions in Patent Law. I note that our discussions have particular emphasis on patent prosecution. I'm Joe Murphy.
I'm Reza Mollaaghababa.
I'm Reza Sadr.
So we have a really interesting topic today. We're going to be discussing whether an inventor making a public disclosure of their invention prior to actually filing the patent application can, in some circumstances, be advantageous. So we'll get into that. And I think, Reza Sadr, you wanted to start us off?
Sure. So if we go to the first slide, this discussion revolves around a recent decision by the Federal Circuit in the case of Sano v. Kaijet. And we can go over the posture of the case, just essential elements that happened here. At issue is the validity of a patent that is signed to Sano and for which the inventor is Liao. Sano sued Kaijet, and Kaijet replied by filing a petition for IPR to challenge the validity of the 429 patent, the Liao patent. And eventually the Patent Trial and Appeals Board sided with Kaijet and found all the claims that are at issue obvious. One of the references used in the obviousness decision was a patent publication by Kuo, and that will become more relevant as we go on. Sano appealed to the Federal Circuit, and the Federal Circuit Court of Appeals for Federal Circuit affirmed and essentially agreed that the claims are obvious. What was the question on appeal was the issue that Sano raised, that the Kuo reference was eliminated by an earlier disclosure that Sano had made, and we're going to make that more clear as we go on. So if we go to the next slide, please. Here, just outline of the events to orient ourselves. All the way to the right is when the Liao patent, the patent at issue, was filed on April 27, 2017. A few months before that, the prior art by Kuo was filed. And a couple of weeks before that, we have two events, at least a couple of weeks. One was an offer for sale of a gadget, a device, hyperdrive, by Liao to Sano. And this hyperdrive, which will be explained further by my colleagues, essentially embodied the claims that were at issue, the invention. And also a bit later, Sano placed an order for those drives. Here I should give credit to Dennis Crouch's Patently, where in early August it has a posting about this ruling, and some of the arguments that we are going to raise were also kind of inspired by that post. If we go on to the next slide, please, let's zoom in into the law, which was very much at issue here. On the left, you see the section 102 of the patent law, which essentially defines prior arts and that can be used against a patent or patent application. And in particular, the subsection that is relevant here is subsection A2, which is boxed in red, which defines one type of patent prior art as a patent application that was filed before the effective filing date of the patent and was later either issued or at least published. And this is supposed to apply to Kuo here, but the same section defines exceptions to the types of prior arts, and one of them is under subsection B2B, which is boxed in green here, which essentially says that a reference may be eliminated if before its filing, a reference, of course, under that subsection A2, if before its filing, there was a public disclosure by the inventor or a joint inventor, so on and so forth. And this is usually known as the 1 year grace period when you looked at from the point that if the inventor makes such a public disclosure, they have a year to file the application with some caveats, and that grace for 1 year comes from the other parts of the law, which is now boxed in blue here. Well, here on the right, I have also copied the older version of the law, pre-AIA, because it's relevant to this case. The point being that while this case came out in favor of Kaijet and against the patent at issue, in the older version, it would have come out most possibly different, because there, as we know, the paragraphs more or less mirror what we have in the new law. In particular, paragraph E more or less mirrors that subsection A2 that we mentioned earlier. However, because the old law was based on first to invent and mentions invention as opposed to filing of the patent, here, and that's boxed in green, for this case, probably Sano would be able to argue that the invention happened before Kuo, as we know, because there was already a product that it was selling and it embodied the invention. So most probably the case would have come out to Sano's favor, but not under the new law. And we're gonna get more detailed about why. If we go to the next slide, please. Here, let's put the two together, the timeline and the law. So essentially, Kuo, which was filed on December 13, 2016, satisfies that subsection A2 of 102, and there was no argument about that. That was accepted. What was at issue and argued was whether the November and December sales of the hyperdrive would constitute that exception under subsection B2B on the right, which is shown by the arrow. And that's what we're going to discuss, besides the details of Kuo and Liao, which my colleagues are going to do. So, Joe, back to you.
Thanks so much, Reza. That's a great setup for us. I think as you showed in a couple of your slides, basically there's a product you can just buy that's at issue here. It's the Sanho Hyperdrive docking station. And obviously these things we've all got them. You know, I got one on my desk here right now. And it's an extension that allows you to plug in your peripherals like your microphone or your earbuds or a different monitor or printer or whatever into the port itself, the docking station, and then that plugs into your main computer, your laptop or MacBook or whatever. So that's really kind of what is at issue here. And this is the claim, and I've got the highlight in there so you can kind of follow along a little bit. I'm not going to read it. So basically, the 429 patent kind of is directed to a port extension apparatus, that docking device, for extending ports of an end user device, such as a laptop, as I mentioned. The spec describes series of ports and connections, as well as a data control module, which allows the devices to connect to data ports of the end user device, and allows for connections between the peripheral devices and the computer itself. I'm going to go to the schematic. I think it's probably easier to kind of see from the schematic perspective what's going on here. So in the red circle, we've got the end user device. Sort of the big box in the middle with all little boxes inside is the actual device itself, the actual docking device. And you can see there's first data port module, second data port module, there's a memory card, video port module, there's some data transmission control modules and things like that, which I think Reza will be discussing. And then in the green is the to be connected device. So that's the device that, the monitor or microphone or whatever that you're going to be looking at. So I think, Reza, you wanted to go over the prior art a little bit, maybe.
Sure. So if we can have the next slide. As it was mentioned, the issue here is that whether the so-called Kuo reference is in fact prior art, or can it be eliminated based on the disclosure or the sale, in fact, of the device by Sano. So Kuo was used in combination with the primary reference, Quan, that is indicated here on this slide, to argue that the claims of the patents were obvious. And this Quan reference has to do with a docking station, and you can see a computer, which is here shown in red, can dock onto the docking station, which is blue. The docking station can then have terminals at the back that can allow the computer to connect to various peripheral devices. So it sort of shows a lot of the elements of the claim, except that the schematics or the design of the control system wasn't shown in this Quan reference. And for that, if you go to the next slide, the petitioner, the challenger, relied on the Kuo reference that, again, is also a docking station, and it performs a similar function. And if you go to the next slide, it, in fact, describes the control unit and the various control pathways that are there and how the signals can be transmitted to various terminals. So the petitioner had basically combined these two references to argue that the claims are in fact obvious. And the issue, as we have been saying, is whether Kuo in fact could be eliminated as a prior art reference based on the sale of Sanho's device or other potential disclosures that they had made regarding their device. And this takes us to the CFC analysis, CFC decision, and how the CFC viewed the facts in the matter. And I think, Joe, you're going to discuss that.
Yeah, I think one thing I might want to point out before we get into it. Now, this is obvious. This is an obviousness rejection. So the claims are found to be invalid for obviousness. And then, but the statute we discussed was 35 U.S.C. 102, which is, of course, has more to do with novelty anticipation. So just wanted to point out for the folks that in order for a reference to be available under 103, as for obviousness, it has to be available under 102 as well for these purposes, as far as when it was published or when the effective filing date was and those kinds of things. So if you're looking at, just for the patent prosecutors out there who might know this, but other folks as well, if you're looking at obviousness rejection, one of the first things you're going to do is to look at the dates, the relevant dates of all the art that it was cited within that obviousness rejection, see if, hey, can I knock any one of these out? And I'll just mention briefly, while this 102 B2B exemption is not common, the B2C exception to prior art is kind of common. You see that quite a bit, because the B2C one is about whether a commonly owned application or patent, that was filed before the effective filing date of the application at issue, but hadn't published yet, can be knocked out. And you can knock it out if you can show common ownership or that they need to be commonly assigned, something like that. So these issues come up if you're looking at a 103 rejection, an obviousness rejection, and you want to double check the dates of everything, see if you can knock something out on a technical reason like this one. Now, that wasn't so relevant here. And the other usual thing that you look at in an obviousness rejection is, are all the claim limitations met? Does it meet all the technical requirements of the claims, things like that? That didn't really come up too much in the CAFC analysis, the Court of Appeals for Federal Circuit analysis. Basically, it was just looking at the relevant dates and what was disclosed when, and whether the reference was sufficient or not. The disclosure was sufficient. So basically, the court said that before Kuo's effective filing date, the inventor of the 429 patent, so the 429 patent was actually assigned to Sanho. It was invented by someone else who didn't work for the company. And I think it's important. I think we're going to maybe we'll discuss that a little bit. But the inventor of the 429 patent had actually communicated with Sanho's, the company, on the messaging service WeChat, and sent to Sanho via private courier a finished version of the hyperdrive, the actual physical drive. And Sanho had bought it. So they placed an order with the inventor of the 429 patent, the one at issue, for 15,000 hyperdrives. And Sanho sent them the payment amount of $153,000 for the hyperdrives. And the odd thing is, there was no non-disclosure agreement, no confidentiality agreement, no joint development agreement, just sold it. And that was it. So the court looked at that and said, the holding is that the sale from the inventor of the 429 patent to Sanho, the company, which later got assigned, to which the patent was assigned, did not, quote, publicly disclose the relevant subject matter. And there was no indication that the sale disclosed the inventive subject matter to the public sufficiently for the exception to prior art in section 102B2B to apply, because Sanho failed to show that the subject matter of the invention itself was publicly disclosed. And that's kind of it. I think we're going to discuss a little bit, but I think I have a couple of thoughts on this one. The first thought is, how much disclosure is needed for it to be publicly disclosed?
I think the case basically, I believe, said that it should be reasonable amount of disclosure, whatever what that means, what is reasonable means. But this sort of is interesting because, in a sense, this was essentially a private sale to a company of the invention. If we look at it from another way and say that an inventor would make this private sale and more than a year later would want to patent it, of course, the private sale would destroy the ability of the inventor to patent it. And the argument, the public policy argument there, is that the inventor has basically benefited commercially from the invention for more than 1 year, and so should not be. So this is essentially sort of the other side of the coin, but it's asymmetric in the sense that here the same private sale, the inventor cannot benefit from it in terms of the exception in this case, and say, well, it embodies the prior art, what I sold, and therefore I am entitled to the exception. And I think the public policy rationale perhaps is that, well, I mean, you haven't disclosed it to the public. The public doesn't know about how this invention operates, how it's sort of is done, and so we shouldn't really benefit from the exception. So I thought that's kind of interesting sort of dichotomy in a way.
Well, the other thing I think, if I may, this concept of public versus private sale, how many people do you have to disclose this to for it to count as a public sale? I mean, there's no joint development agreement, like I mentioned. There's no confidentiality agreement. It was a sale. So, if you sell me something, aren't I a member of the public? How is this a, quote, private sale? That's what I kind of don't get.
Yeah.
I can understand the disclosure aspect. Possibly it was not disclosed in enough detail, I suppose, but I didn't quite understand the distinction, which seems pretty fine to me, between a private sale and a public sale.
Well, I mean, I think to some degree, it seems to me that the idea of at what point the disclosure is enough. I mean, we know, for example, in terms of the printed publication cases where, something is disclosed to a small number of people, at what point it is really a printed publication. So there's all those issues that you have there as well, right? I mean, is it, if you I was involved with a case where something was discussed in a working group, but the working group was a very closed circle of people, and then the question was it really a publication? So I think to some degree, I'm not saying that the case law here with regard to disclosure is not necessarily the same, but it seems to be sort of a reasonable disclosure to the public. Now, whatever, that means.
I think that's important. I think both of the points you raised comes back to the dichotomy and asymmetry that Reza mentioned earlier. It makes it much easier to understand the thinking if you remember the philosophy behind the patent law, which is it's a quid pro quo, like an agreement between the inventor and the society, that we give you this exclusion right if in return you provide the benefit of your invention to the public, at least to the extent that after a while actually it becomes public property. But even during that period, they should understand your invention to even be able to reproduce it and build on it. So I think Sano tried to use the argument that the private sale, if it can be used as prior art, why cannot it be used also as the shield against it? But the counter argument was exactly what I said. And again, it comes back to the point you raised, Joe, that how public it can be such that we can say that benefit has been provided to the public, that they
It
can
becomes a little bit, sorry to interrupt you, but it becomes also a little bit complicated because as Joe was saying, let's assume that this was put on sale, and not with regard to Sanho, it was a huge sale of this device. Millions of these devices were sold, but there was no disclosure of the inner workings of the device. But it could have been opened up and reverse engineered or something to that degree. Would that be considered as sufficient disclosure? I don't know the answer, but I mean, at one level, you can say, well, if it was sold millions of copies and people could have just simply opened it up and see what's going on. But on the other hand, the argument can be made that no, that is not sufficient, if you didn't really explain, the workings of the device or the circuitry in the device in this case.
I think.
Could
Oh, go ahead, Reza.
Sorry. Could again the famous prestigious person of ordinary skill in the art come into play here to figure out whether they can figure it out, for example, through the reverse engineering based on that. And of course, that's one of the unanswered questions. The other one, as was mentioned, is that there was some other kind of public disclosure in the case that, according to Dennis Crouch, it was not even addressed by the court because they said it was not raised on a timely manner by the appellant, right? There was such. Is that correct?
It wasn't mentioned in the briefing properly. I think they didn't mention it until the respondent brief, or I think that's what it was. Like I said, I'll have the link to the article below. One other thought I had, I want to give a caveat or a warning to the folks watching this, and then we'll get into whether this is a good idea to try to this as using it as a shield. One thing to think about. And obviously we have a lot of clients who file in the US, but most of our clients file internationally as well. And so the US is a jurisdiction where there is some leeway as to when the first disclosure comes and when you can file the application and still get it. But other jurisdictions such as the EPO and China and Japan might have a little wiggle room on this one, but they require absolute novelty. So if you have any thought about that, at some point you want to file your application internationally, do not do this. Do not think, oh, you know what, I'll disclose this a couple months early, then I'll file my application. I can protect myself, maybe something like that. I don't think it's a good idea. But what do you think? Is there any circumstance in which this might be a good idea?
One of the other things that I think it's important to remember is that for this to work as a shield, the disclosure it should be identical to prior art. So even a small deviations may sort of eliminate this as a shield to help you. So that's another problem because that means that, and I don't know whether in this case also, I mean, even though they didn't address it, I mean, but explicitly, but even the YouTube video that wasn't considered may not have worked because it could be that the circuitry and the path of the signals may not be exactly the same. So in that sense, even in the US, it's a very, very narrow exception. So to me, I think the best strategy to really file and not rely on this.
Yeah,
I fully agree. I fully agree. I mean, I think if there's any takeaway from this case, is the same advice we always give our clients almost every time, that don't rely on the grace period. I'm thinking grace period usually comes out after the fact as a retrospective thought. What does that mean? When you find out about the prior art and then you go scramble, did we do any prior disclosure before that to somehow remove it? But it's never a good idea if you know maybe some public disclosure or some prior art, some art is coming out before you're filing, and then say, oh, let me do a public disclosure to preempt it. And that doesn't make sense ever, almost ever, for all the reasons you mentioned. So always it's a good idea, as Reza said, if you are in any doubt, file. And there's a reason it's called a grace period. Usually people, when they maybe inadvertently or for any other reason publicly disclose their invention, they would say, oh, I have a year of grace period to file. And the answer is no, don't do that.
Right.
Most often, go ahead and file as much as you can at this point.
There are circumstances where people may not be interested in patenting, but they do not want to be stuck with a third-party patent that would, destroy their ability to practice the invention. So, of course, in those situations, people do publish, do disclose, just to sort of generate prior art relative to others, and hopefully won't be stuck with patents that would prevent them from practicing what they like to do.
Right.
True.
All right. Sounds good. Well, that's a great discussion, and it was a really interesting topic. So great. Thanks so much.
Thank you both. Bye.
Thank you.
See you later.
Bye-bye.
Bye-bye.